Hi, I'm Hennepin County Attorney Mary Moriarty. Thank you for joining us on our podcast, We Don't Have to Choose. We talk about the ideas that you don't have to choose between public safety and change or reform that's based on research. Did you know that children as young as 10, 11, and 12 can be charged with criminal offenses? They're not called criminal offenses, but they are crimes in Minnesota. That's going to change soon because of legislation called Raise the Age. Today, we're going to talk to experts about what Raise the Age is all about and why it's really important. We are first going to talk to Representative Sandra Feist. Hi, I'm here with Representative Sandra Feist, who has taken a special interest in Raise the Age legislation. Hello.
Hi, thanks for having me.
Of course. Can you tell us why Raise the Age is so important and why it's been important to you in particular?
Yeah, well, since I was elected, I really focused on kids, and this is a really important issue impacting young children in our state. I felt like it was really important that we don't put little kids who need help in jail. And I also know, as vice chair of the Public Safety Committee, that the system involvement is actually something that creates further system involvement and endangers public safety. So this was an issue that is about supporting kids and also protecting public safety.
I think it would surprise a lot of people to know that children as young as 10, 11, 12 can be charged with crimes. We call them delinquency or we petition them, but it's still the same. They can be charged with crimes. And I think it's surprising to people because if they look at 10-year-olds they know, and they try to imagine explaining the criminal legal system to them and their rights, they just can't imagine that a person that young, a child that young can really understand that language, that system enough to be able to navigate the system.
Yeah, I think to highlight it, I was talking with a friend who represents these kids, and he said that recently at the Juvenile Detention Center, they haven't been letting him bring in his coloring books and his magna tiles for his clients. And it just really brought home to me that we are talking about little kids who are supposed to be represented by lawyers and representing their own interests in courts. But these are elementary school kids, and they should not be in jail.
So tell us what Raise the Age is. What was that legislation about? And it did pass a couple of years ago, but tell us what that's about.
Yeah, so it's been a long time coming. We first passed this legislation in 2021 off the House floor. And the new law basically just says that kids who are 10, 11, and 12 who currently can be criminalized can no longer be criminalized. We're going to cut that age off at 13. And so obviously, we should think about 13-year-olds too. I'm the mom of two teenagers. I don't think they understand the legal process very well either. But it's a really important moment of progress in Minnesota to make sure that these 10, 11, and 12-year-olds, as of August 1st, will no longer be criminalized. And we did that first in 2021 in the House, and then in 2024 with full engagement from all of the stakeholders. So people representing these children, people representing public safety, people representing the counties, the social services. We worked with them to pass this law in 2024. We built in a 2-year period for the system stakeholders to adapt and to make sure that we were ready on August 1st of this year to support these children rather than put them in jail.
So you mentioned the 2-year ramp. And that was to give system partners, that kind of thing, the opportunity to get prepared for this legislation. What did they need to get prepared for?
Yeah, well, as you know, in Hennepin County, there's a lot that they could be doing. Basically, we need to be thinking about, how do we give these kids support, services, interventions in a timely manner? So what has been happening and what we were trying to address is the fact that these kids were delayed in getting those services and those interventions, figuring out what makes a 10-year-old do something dangerous and destructive. And instead, they were being held and traumatized, and no plan was in place during that period when we were looking at whether they were able to stand trial, which almost none of them are. And so what we were asking the system to do is to look at what are those interventions that can be provided to kids and families that don't need to be provided in the context of a juvenile justice system.
So you used a lot of different or there's some acronyms in there, like, and juvenile detention center.
Mm-hmm.
So when we as prosecutors charge a child who's 10, 11, or 12, and a court thinks that it's important that that child be held because they might be a danger to the public, or actually they might be in danger.
Mm-hmm.
They are actually held here in Hennepin County at a place called the Juvenile Detention Center.
Mm-hmm.
And you mentioned that.
Mm-hmm.
And I think that's where you said you were talking to a friend of yours who represents a client who is a child,
mm-hmm.
and he was bringing in coloring books for
mm-hmm.
that child. So we can be grounded in how old,
mm-hmm.
like the age level that we're talking about with children. So you also mentioned something that I think is really important. When you put a child in essentially a child jail, it's a jail,
mm-hmm.
And that's traumatizing and damaging. Can you talk a little bit more about why that's the case? I think it's probably obvious when people think about it, but sometimes people don't think about it.
Yeah, I mean, I just think about it as a mother, honestly, mm-hmm. as just like a layperson in the world, that when you are separating a child from their family, from their community, from their toys, from their sense of self and support, like that is traumatic. And that, leads them further like into the system. Like we know that, people who have experienced trauma and harm are often the ones who then are creating harm. And so, we are trying to move forward from a system that is traumatizing these little kids, isolating them and scaring them, to a system that looks at what are the underlying factors. So I think about the fact that there was a study in Houston where a way overrepresentative sample of those kids in juvenile detention had dyslexia. So we know that a lot of these kids who are struggling in school and with behavior are doing it because they have a disability. It might be dyslexia, it might be something else. And so we can look at these kids as kids and we can identify what they need. And what they need is something that we need to be ready to provide. We need to provide more support at school. Maybe they need more support at home. Maybe their family needs support. And we as a society have an obligation to figure out what they need for their benefit as human beings who deserve our support, and for all of our benefit as a community that deserves public safety.
And you're talking about public safety.
Mm-hmm.
And I know that there are fears by some people who are not ready for this change. And they may say something like, and we know this to be true, there are 10, 11, 12-year-olds who are out there engaging in behavior that may be harmful to themselves or others. What have you said to those people who say, hey, this is a bad idea? There needs to be something for those that age, and even younger, actually, mm-hmm. 9. But at least in that age where we can, right now, charge them criminally, what are we going to do mm-hmm. if we can't do that anymore?
Yeah, well, it's really clear that the status quo is not working, mm-hmm. That these kids are almost universally not constitutionally permitted to be held in detention and tried in our criminal legal system. And so that's the status quo, and that's what we're trying to move away from. So the current system is not working. It's not working for public safety. Kids are coming in, they're being found not competent, they're being let out. And in the meantime, we could have been figuring out what do they need. And so that's what I'd say, is we need to figure out what those kids need. And, systems really resist change. If there's been one big observation I've had in my time in the legislature, is that systems don't want to change. And sometimes it's the legislature's job to affect the will of the people who say that children should not be in jail. They need help. And that is the law that we passed. It's what the people of Minnesota want. It's what public safety needs. And I'm really proud of it.
Where do we stand in Minnesota in terms of raise the age and age where we can criminalize a child in the rest of the country and in the world?
Yeah, well, my understanding is that we are now the best in the nation, that we are the only state that has that threshold at 13, or that will have that threshold at 13. There are some other states that have carve-outs for certain types of offenses, but that really doesn't make any sense because the seriousness of the offense does not somehow correlate with competency to stand trial. So kids who are causing the most harm need the most interventions, and they need those interventions faster, not after a long, protracted competency process. And so what we've done here is evidence-based. It's based on what we understand about childhood brain development, and we are the best in the nation. And I'm really proud of that.
And you are leaving the legislature.
Yeah.
You had your last session recently.
Yeah.
And I'm imagining that this is something that you're very proud of.
This is something I'm very proud of. I think the things that I will look back on with the most pride are the things that I did for kids. So we created an Office of Restorative Practices, which is just part of this bigger picture, looking at, how do we heal harm? How do we do it in a way that helps people who have been harmed not go on to cause more harm? How do we provide closure for victims? And so, I'm excited for the Office of Restorative Practices to work with counties, with corrections folks, with communities to help, use those restorative practices in this context. So I'm really proud of my time in the legislature. I've got to go be an immigration attorney. That kind of needs all of me right now, but I will definitely miss it.
And thank you for that resource too, because one thing I've learned as county attorney, that what we do in the system, whether we put somebody in jail or whatever we do, really is not healing for people who've been harmed. That's not, they may get closure because a process is over, but it certainly doesn't help people heal. So thank you so much for giving us that resource. And thank you so much for all that you've done in the legislature.
Thank you so much. It's been an honor. Is it okay if I say one more thing?
Of course it is.
I was just thinking, there are people who are afraid of change and resistant and concerned. And I give those people a lot of grace because I think they really deeply care about these kids in our community. And I know that restorative practices and, those types of interventions are something that are broadly supported. And so I feel a lot of hope that even those who are nervous about change and maybe don't want change, I know that there are a lot of resources that are going to be brought in and utilized by those folks, and that this can be a success. So I just wanted to mention that too.
Thank you.
Yeah, thanks for having me.
We just heard from Representative Sandra Feist about the Raise the Age legislation. And now I'm here with Sarah Davis, who's the deputy in our office. And she was a major driving force to help with this legislation. Welcome, Sarah.
Thanks so much. I'm excited to talk about this.
Yeah, Representative Feist was talking a little bit about competency. And I know that that's a confusing concept for many people.
Sure.
Would you mind explaining what competency is when we're talking about children? It's true of adults too, but particularly when we're talking about children.
Sure. So under our Constitution, we have due process rights. And one of those rights is that if you're going to face criminal charges, essentially, that you have to be competent to assist in your own defense. And what that means is it's not a measure of how smart you are. When we're talking about kids, particularly really young kids, they just simply don't have the neurodevelopmental capacity to understand what's happening. And so this can include things like they have to be able to understand their trial rights. They have to understand their due process rights because they may make decisions to waive those rights. And as an attorney, if you're representing a child, it's not the attorney's decision about whether to waive rights or go to trial or, enter into a plea bargain. It's the child's decision as a client. It's not the parent's decision. It's not the lawyer's decision. And in order for them to make an informed decision, they actually have to understand the rights, understand what the options are that are available to them, and then be able to effectively work with their lawyer. And when we're talking about kids who are in elementary school, fourth graders, fifth graders, they just simply don't have they're not developmentally able to do that. And I think, obviously competency is a complicated legal topic, but I think like when we just think about children in our lives who are 10 and 11, 12 and fourth or fifth grade, it makes sense that they're not going to be able to understand all the different people's roles in the courtroom, all the different plea options available to them, all of their constitutional rights.
It's interesting. I think people would understand that if they were actually thinking about elementary school or their own kids or something like that, but somehow there's a disconnect there. And sometimes I think about when I'm talking to people, I'm trying to explain the criminal legal system, and they have lots of questions, understandably. And then I'll say, well, how do you think a 10-year-old or 11-year-old would understand that? And they would say, absolutely not.
Absolutely. And, I spent a long time in my career representing kids and have a lot of kids in my life, including my own kids. But, I think a lot about kids when I've represented children. Like, kids will come to court and you have to picture a young person who's wearing like a Mickey Mouse t-shirt, right? And whose feet don't even touch the floor. And, whose reading skills are, really not even close to where they would need to be to sort of read some of the documents that are available to them. And, I think you can, as a lawyer, become really good at teaching and explaining, as you talked about. And I developed a skill related to that with kids. But at some point, you just have to recognize that kids of this age range just simply can't. And internationally, there's the United Nations Conventions on the Right of the Child, and they recommend 14. And internationally, that is the most common, is 14. Because of this very issue, right? And the related competency issue here is that when a child is not competent, nothing can happen on their delinquency case, which is our juvenile court word for criminal. And so that means there can't be any court-ordered interventions. They can't be held in a juvenile detention facility, a correctional facility. The whole case has to stop and be put on pause until they're competent. And that's just a fundamental constitutional right. So it's not about saying that, kids in this age range can't cause harm. They absolutely can. Or that we shouldn't intervene when kids cause harm. We absolutely should. It's about how do we intervene that is effective for this group of kids and in a way that we actually can under the law, and we just simply can't because they're not competent.
So who decides competency? How is that actually determined?
So actually, it's the judge who makes the ultimate determination. But the way it works in court is we're required by law, under our ethical rules, to anybody who's involved in the case, to, if we have concerns about whether the child is competent, or even if it's an adult, if they're competent, to raise that. And then the court orders what's called a competency evaluation, and a psychologist completes that evaluation, meets with the client, the child, does a whole series of tests, and tries to help them understand the legal process, see if they're able to retain that, tries to get them to make some reasoned decisions, and then they write a report for the court recommending whether they're competent or not, and then the judge ultimately decides.
And you mentioned an important point there, that ethically, really, too, any party, either like the judge, prosecutor, defense lawyer, whoever, if they believe that there's a question of competency, any party can raise that. It's called a 2001 under the rules, but a competency concern.
And it's not just that they can, they have to. It's an obligation under the law that we're supposed to do that. And so even if you're a defense attorney, if your client says, I don't want you to raise that, you still have to. That's the law that we operate under.
And do you have thoughts on where that came from? Why don't we prosecute people who aren't competent?
Well, I think when we think about it, our constitutional premise here, right, is that people are presumed innocent until proven guilty. They have the right to be able to contest any charges that are being brought against them. And at the end of the day, it's their case. It's not their lawyer's case. Their lawyer has to take their direction from that person. And if they can't meaningfully participate, then, what are we doing here? We're subjecting people who can't participate in their own defense to punishment without giving them a meaningful opportunity to be heard in their own defense. And, again, we're talking about fourth graders, fifth graders, elementary age kids, right? And the outcomes are very real. If we prosecute kids at any age, right, we're talking about kids in locked jail cells. And I think sometimes people who haven't been in these facilities don't understand. Steel bars on doors, truly jail cells for children. And that's what we're talking about for 10, 11, and 12-year-olds here, which will no longer be an option, after August 1st.
So I wanted to go back to the process. So a judge, or let's say a psychologist says, in their opinion, this child is incompetent or not competent to proceed. the judge accepts that and decides that the child is incompetent, even for a child who may have harmed someone else who's being held at the juvenile detention center, what happens then?
Yeah, by law, they have to be released.
So it's not our choice as prosecutors or the judge, or I mean, legally they cannot be held.
Correct. Under the law, they have to be released. And what that really ultimately does under the current system is that it just leads to this really lengthy delay before any interventions can be put in place. Because if that child needs court-ordered interventions, it cannot happen on the delinquency matter. So now they've been found not competent, they have to be released from the juvenile detention center, and it's only at that point that we can start looking at child welfare or child protection interventions. Child protection interventions can be ordered by the court. And so, that's really the avenue that we're pushing to say, if we need those types of interventions, let's get right to it. Because what we know about kids, and the research bears this out, but like anybody who's interacted with a kid knows this, is that you can't wait months and months and months to intervene. Like, you need to be able to intervene quickly and effectively to really change course and have the impact that we're looking for.
So one of the issues that we have had to deal with in our tenure, is children, sometimes as young as 10, 11, 12, who are committing sometimes harming people in a violent way, and they are incompetent. And as you said before, a child is capable of harming someone and does need services, and sometimes in a more secure setting. So what has happened to those children over the years here in Hennepin County?
So as you mentioned, it is true that there are some children, even at this age range, who cannot safely be at home for a period of time, and who may need a more secure setting. In the past, they've maybe been booked into the JDC, but then had to be released. Sometimes folks call this the revolving door, and we're trying to stop that with this, right? We're trying to put in place really meaningful, effective interventions. In Hennepin County, within the last year, the county opened a space at 1800 Chicago, which is an opportunity it's a secure facility where children can be to receive evaluation and determine what their treatment needs are. And so that is an option. And actually, under the law, as it currently exists, even once this law changes on August 1st, children can be held for up to 24 hours in a juvenile detention facility if need be, right? And so while a plan is figured out. And so, and that applies to, quite frankly, a child of any age. But the truth of the matter is we really do need to invest in resources in our community where we can truly provide the supports and resources that children need who have our most complex behavior and mental health and emotional needs. And they don't exist to the degree that they need to. And so that is a future investment that I hope to see happen. But I do want to point out that when we talk about the kids who engage in serious harmful behaviors who are not competent, we're talking about just a very small percentage of the kids that in this age range who are currently under the jurisdiction of the court for behaviors in their at 10, 11, and 12 years old.
It is a tiny, tiny group that often has very complex needs. And I think for the public, sometimes those are the young people or the children that police will talk about, and they'll talk about a revolving door, but you've explained the legal mechanisms that make that happen. And as we know, there was some effort to delay implementation of Raise the Age. Why do you think that was? Why are people so reluctant to jump into this and do what we've been talking about, which is actually provide the services that these children need, instead of putting them through the criminal legal system, essentially, where they are most often incompetent and it delays the process?
I mean, first of all, I think change is hard, right? This is the way it's been for a really long time. I also think that it's because it's so complicated, people don't always understand that, in fact, the way that the system is set up at this point, until August 1st, is actually a significant contributing factor to the problem that they've identified. And so, it's complicated, it's hard. And, we have historically not invested in providing the supports and resources that our children and families with our most complex needs have. Now, I do want to be clear about that. We do provide supports and resources for folks who have the means to obtain that, right? And so mostly what we're talking about is Black and brown kids and families who don't have access to financial resources. Because for those who do, right, like who have private insurance, who have the ability to access mental health, there are places where we can intervene early and kids can get the supports and services that they need. But in this context, what we're really seeing is, we've not invested in the resources for those who don't privately have the ability to do that. I do think, though, it's worth saying and like spending some time talking about like the 99% of kids for whom like they are not in this category, right? And I'm thinking about like a young person back in 2018 or 2019, outstate Minnesota, severely has severe emotional needs, right? And has significant supports in school through an IEP, special education needs, and had an incident of dysregulation at school involving a pencil and trying to cause harm to a teacher, and very young, like 10 or 11 years old, had never been away overnight from his family and was arrested at school and brought to a juvenile detention center and held over multiple nights and had to be in what we call a pickle suit, right? Which is is a suit where you can't cause harm to yourself or others, but you're fully restrained in your body. And just decompensated in that facility, clearly not competent, clearly not able to participate. And when eventually was released home to his mother, who was desperate to get him home immediately, but could not, didn't leave the house and didn't go back to school, and really just completely impacted the trajectory of that child's life. And again, it's not to suggest that it's okay to cause harm in that context, but what are we doing when we're taking, a severely autistic 10 or 11-year-old and locking them in a jail cell in a pickle suit for behaviors that are anticipated as a result of their special education needs, right? Like, we shouldn't be doing that. Or not that long ago, we had a kid brought into our juvenile detention center for stealing candy. And from a store, and the store said, yeah, they'd been repeatedly there stealing candy. And, the kid was like 10 or 11 years old. And this is it literally stealing candy and running out of the store. We're talking about a kid in fourth grade. What are we doing when so that's really what we need to be thinking about. What are we doing to, the 99% of kids in this age range who are not, super high risk to cause harm to somebody, that we are criminalizing, impacting the trajectory of the rest of their lives. And this law that Representative Feist championed at the legislature, that I'm so grateful that this is a joyful moment, right, for Minnesotans. And we are setting the precedent for the rest of the country here.
Thank you.
Thanks for having me.
You've heard from Representative Sandra Feist and our deputy here at the County Attorney's Office, Sarah Davis, really talk about the legislative piece of what we call Raise the Age and the technical aspects of it. But what does it really mean? Think about the idea of putting a 10-year-old in what is essentially a jail cell. That is what the juvenile detention facility looks like, and that's what it feels like to a young person. That's something that we definitely do not want to do, and something that no parent wants to have happen to their child. So what this legislation really means is that instead of charging 10, 11, 12-year-olds with criminal offenses, they will get the help that they really need, and not in a jail setting. The criminal process itself delays the ability of the system to respond to children's needs. And we know in this day and age, especially, we've got a fairly small number of young people who really struggle with complex mental health needs. And they just need help. They don't need to be in jail. So that is why the legislation that is going into effect later on August 1st of 2026 is a gigantic step forward. Thank you for joining us on We Don't Have to Choose.